You.
Good afternoon.
There was David Davis, the Secretary of State for Brexit in the European Union. He was specifically asked what is expected of Parliament now, and he was cogitating on some of the potential avenues that lie before the government. There could, he thought, perhaps just be a resolution. Both houses of Parliament, would they be involved? Would there be an act? Where does it go, assuming the Supreme Court doesn't overturn today's decision?
I certainly see the judgment as it's been given by the High Court as indicating that there has to be primary legislation, a statute passed by the House of Commons and the House of Lords and signed by the Queen. And the reason for that is because the issue in front of the High Court was whether you could undo statute law by a proclamation, by the use of the royal prerogative saying we are leaving the EU, thereby depriving large numbers of people in this country of statutory rights enacted by Parliament of the United Kingdom, which they currently enjoy. And what the judges said is you can't do that. And indeed, the case law on that goes back a very long way. It goes right back to the 17th century. Indeed, you can trace it back to the Middle Ages. And so what's needed is for the government, I think, to introduce a piece of primary legislation in Parliament so that it's debated in the House of Commons, passed in the House of Commons, taken to the House of Lords, who debate it and pass it, and then it's signed off and given royal assent.
So a bill, both chambers debating, we can expect a lot of toing and froing from the upper chamber to the lower chamber. That all sounds like it would take an awful large amount of time, and the likelihood, therefore, of getting to March next year and invoking Article 50, as was planned by the Prime Minister, begins to look vanishingly slim.
Well, I'm not necessarily sure about that. I mean, I certainly think that any piece of legislation could well be rather short in its terms, but it's true that it is debatable and amendable and will allow an opportunity for debating all the issues surrounding Brexit and where we go once Article 50 has been triggered. But at the end of the day, you can get primary legislation through Parliament quite quickly. It's been known to be done in 48 hours, but that's as an emergency. I don't think we're talking about that. But it might delay slightly the enactment of a triggering of Article 50, but it's worth bearing in mind that the government isn't ready to trigger Article 50 itself at the moment at all, because it doesn't really know at the moment what it's going to do next.
However short it is, it will have the effect, say some Brexiteers, of showing the Prime Minister's negotiating hand. Rather than her entering negotiations with our European partners, knowing what her red lines are, knowing what her negotiating positions are, well, the people she's negotiating with will know them too.
I rather doubt that. I don't think anybody in Parliament would insist on knowing what the government's fallback position in any circumstance would be. The government's opening position, once it's been opened, will be known to everybody and will leak out within minutes, because the European Union is certainly not going to keep it confidential. So I'm not so certain that it's going to hinder the government's ability to carry out a proper negotiation.
Can I just ask you about the man who succeeded you as Attorney General, Jeremy Wright, who elected, we think it was his decision to personally try and steer this through the High Court. Was that folly? And if it was, and in particular if it doesn't get through the Supreme Court, ought he to consider his position?
Not at all. This is an issue of law, not of politics. It is what is the law of the land in the United Kingdom. And as we have an unwritten constitution, there are areas of constitutional law that have to be interpreted by our judiciary. I have no criticism to make of the government in deciding to have this particular issue of law explored by the High Court. I have to say I think the High Court's judgment seems to me to be utterly rational, and I rather predicted that this was going to be the outcome. So I'd have no complaint about what's happened, and the Attorney General's acted perfectly properly in representing the government in court. In any case, it's not his decision, it's the government's decision whether to contest a case or not.
What will you say, Dominic Greaves, to some of your constituents, and doubtless they'll be there, who will say to you, what's happened today is an example of judicial activism. 3 unelected judges have, to borrow the word that was used by Theresa May not very long ago, subverted democracy and defied the will of 17.4 million voters.
There is a hugely well-established principle in this country that laws and statutes conferring rights on people passed by Parliament cannot be removed without Parliament voting to do it. That's what this question is about. I fully understand that a majority of the population has voted for Brexit, but Brexit has to be carried out in a lawful process. And if it's not carried out in a lawful process, then it will have no legitimacy. So for that reason, the lawful process has got to be followed, and that must require Parliament to enact the necessary statutory framework to remove all these statutory rights that people are currently enjoying as a consequence of our EU membership, and which have been enacted by Parliament of this country, in the past.
Dominic Grieve, thanks very much.